Good afternoon, everyone. Today is Wednesday, March 18. Welcome to the Judiciary vote session. How's everybody doing? We're almost there, y'all. We're almost there. Okay, so on the first bill, House Bill 11, don't give me a motion yet. I'm going to hold this for now. 11? 11 is a hold. Do you have your new? It's not gonna, I'm not going. Okay. And House 83 is also a hold. All right, 216 will be our first. Is there a second? Second. All right, we have amendments. Okay, we have an amendment on 216. Claire, would you like to tell us what the amendment does, please?
The amendments remove some catch-all language from the prohibition and alter the penalty structure so that it mirrors the penalty structure for theft and related crimes.
So we have a motion on the amendment. Are there any questions on the amendment? It's been moved and seconded. We also have, these amendments are in your amendment packet that was sent out.
It conforms with the Senate?
And it conforms with the Senate? Oh, no, there was one problem, yeah.
Well, the concept of the penalty structure does conform with what the Senate did, but we had to change some of the language because they made a mistake. And also, they didn't take that catch-all language out.
Can I just make sure I understood? Senate made a mistake?
I'm not sure, but did we hear that the Senate made a mistake? All right.
Did the Senate make a mistake?
I think the Senate made a mistake. All right. So there goes our bills. When we, there's all our bills. All right. So any other questions on the amendment, or are there any questions on the amendment or the Senate's mistake? All right. Seeing none, please raise your hand if you're in favor of the amendment. All right, all opposed? None. Okay, that is unanimous. Is there a motion on the bill as amended?
Second.
Thank you. We have a motion on the bill as amended and a second. Are there any questions on the bill as amended? All right, seeing none, please call the roll.
House Bill 216, Delegate Kaufman, Criminal Law, Benefits Exploitation. The Vice Chair.
Yes.
The Vice Chair votes aye. Delegate Valentine. Aye. Delegate Valentine votes aye. Delegate Embry. Delegate Embry votes aye. Delegate Cardin.
Yes, and American.
Delegate Cardin votes aye and an error can. Delegate Phillips.
Aye and an error can.
Delegate Phillips is an aye and an error can. Delegate Congolo.
Yes.
Delegate Congolo votes yes. Delegate Stinnett.
Yes and an add.
Delegate Stinnett votes yes and an add. Delegate Simmons.
Yes and a Conway.
For the record, Delegate Simmons is a yes and an add. Delegate Boucher is absent. Delegate McComas.
Yes and an add.
Delegate McComas is a yes and an add. And an error can, she says. Delegate Moreno. Delegate Moreno is a yes and an add. Delegate Arcon.
Yes and an Arcon.
Delegate Arcon is a yes and an Arcon. Delegate Taylor.
Yes and an error.
Delegate Taylor is a yes and an add. Delegate Simpson. Delegate Simpson is a yes and an add. Delegate Mangione. Delegate Mangione is a yes. Delegate Moon. Delegate Moon is a yes and an add. Delegate Conaway. Delegate Conaway says yeah, which is an aye.
No, yes and A.
Oh, yeah.
Wow.
Okay.
Oh, okay. For the record, Delegate Conaway is a yes and an add. Delegate Woods.
Yes and an add.
Delegate Woods is a yes and an add. Delegate Williams is excused. The tally is 17-0-0-1-2, 17-0-0-1-1. The motion carries.
Thank you very much. We had way too much fun with that. Okay, so we're going to move on to House Bill 281. And what did I do? Just one. I'm just trying to say, there's no amendments, right? No. Okay. So there's a motion to move favorable. Is there a second? Second. Thank you. So on the bill for House Bill 281, are there any questions? Okay, seeing none, please call the roll.
House Bill 281, Chair, Judiciary, Departmental, Family Law, Child Care Providers, Criminal Background Investigations. The Vice Chair. The Vice Chair votes aye. Delegate Valentine. Delegate Valentine votes aye. Delegate Embry. Delegate Embry votes aye. Delegate Cardin. Delegate Cardin votes aye. Delegate Phillips. Delegate Phillips votes aye. Delegate Congolo. Delegate Congolo votes aye. Delegate Stinnett. Delegate Stinnett votes aye. Delegate Simmons. Delegate Simmons votes aye. Delegate Boucher is absent. Delegate McComas. Delegate McComas votes aye. Delegate Moreno. Delegate Moreno votes aye. Delegate Archon. Yes, Delegate Archon votes aye. Delegate Taylor. Delegate Taylor votes aye. Delegate Simpson. Delegate Simpson votes aye. Delegate Mangione. Delegate Mangione votes yes. Delegate Moon. Delegate Moon votes yes. Delegate Conaway. Delegate Conaway votes yes. Delegate Woods. Delegate Woods votes yes. And Delegate Williams? Delegate Williams votes aye. The tally is 18-0001. The motion carries.
Thank you. On House Bill 338, Delegate Simmons, is there a motion? All right, it has been moved and second, and there is an amendment. Actually, I apologize. Thank you. So on the amendment, Claire, would you like to go over what the amendment does? Or on House Bill 338?
The amendments, amendment number 1 alters requirements for notification of an investigation or enforcement, and amendment number 2 is technical.
On the amendment, Delegate Archon.
Thank you, Madam Chair. Claire, can you tell us what the change of the notification, pardon me, actually does? How is it changed?
One moment.
Yeah, no rush. I'm speed reading it, but. Okay, so it requires they notify state police?
State police, when conducting traffic stops throughout the state, that they have to notify them.
After?
Right.
Okay,
Yep.
because it would be impossible to do that
Yeah.
before, right?
Yep.
Okay. And what about other jurisdictions, like if they?
Yeah, so whenever they're moving about the state, if they are in the middle of conducting a traffic stop through their statewide ban, they have to notify state police in real time that they're on that traffic stop.
Okay, so
Wherever
that
they're
they
at.
know, okay,
Yeah, so
okay.
wherever
if
they're
some-
at, yeah.
Some troopers pass by and they're wondering
Right.
why someone's pulled somebody over in their jurisdiction, they'll know, okay. Thank you very much.
Are there any other questions? All right. On the amendment, all in favor, please raise your hand. All right, great, looks unanimous. On the bill as amended. I'm looking at you, Delegate Simmons, this is your bill. It's all good. You're supposed to move your bill. Okay, so on the bill. All right, so on the bill as amended, are there any questions? Seeing none, please take the roll.
House Bill 338, Delegate Simmons. Department of General Services, Maryland Capitol Police, statewide jurisdiction. The Vice Chair. The Vice Chair votes aye. Delegate Valentine. Delegate Valentine votes aye, and an add, Delegate Embry. Delegate Embry votes aye. Delegate Cardin. Delegate Cardin votes aye. Delegate Phillips. Delegate Phillips votes aye, and an add, Delegate Congolo. Delegate Congolo votes aye. Delegate Stinnett. Delegate Stinnett votes yes. Delegate Simmons. Delegate Simmons votes yes. Delegate Boucher is absent. Delegate McComas. Delegate McComas votes yes and adds. Delegate Moreno. Delegate Moreno votes yes and an add. Delegate Archon. Delegate Archon votes yes and an add. Delegate Taylor. Delegate Taylor votes aye. Delegate Simpson. Delegate Simpson votes aye. Delegate Mangione. Delegate Mangione votes yes and an add. Delegate Moon. Delegate Moon votes aye. Delegate Conaway. Delegate Conaway votes aye. And a Simmons. Delegate Woods. Delegate Woods votes yes and an add. Delegate Williams. Delegate Williams votes yes and an add. The tally is 18-0001. The motion carries.
Skip 466? Or do I need to vote out? Okay, all right, so we're going to change House Bill 466. I guess I have to do this as an amendment, so this will be an oral amendment. I'm gonna move, okay, I move that we change House Bill 466 to a summer study. No, this is totally different from the amendment. This is a summer study. For House Bill 466, I am moving that we change this to a summer study.
Second. It's got a second.
Okay. Is there any opposition to changing this to a summer study?
I hope the study does well.
Okay.
It's still going to be manned by the department, right? It's going to MIA.
This
believe.
is my first time doing a summer study, so.
I think that it's not going to change the essence of the study, how it's going to be done, I'm assuming.
We'll find out for sure. We'll find out for sure. Okay, Holly, I'm sorry, did you want to add?
Study right now has a reporting date of December 31st of 2026. Are we changing the reporting date or anything, or we just, okay, so the amendment in the packet strikes the bill as introduced and changes it to a study, but you want this to be?
This is no longer going to be a bill. The bill itself is going away.
Got it.
So it'll
Okay.
be a summer
So we're just
study.
going to write a letter and ask
Yes.
the MIA. Got it.
Yes,
That
yes.
sounds great.
Yes, and it would be MIA who does the summer study.
Okay.
Sorry, I didn't explain that very well, because like I said, it was my first time. Delegate Simpson?
That was a yes to the question I had, which is, this is the thing where you do the letter for the
Yes.
study.
Yes, this is the thing where I do the letter. All right, are there any other questions? All right, seeing none, I think I do need a hand vote on, a roll call vote, I'm sorry. I need a roll call vote to essentially withdraw 466 and make it a summer study? Please help me, Hunter.
So, okay, but there is an option to refer to interim study as a vote here, so we can if she wants to.
Thank you for your indulgence there. If you don't mind, I would like to have a roll call vote for this to be a summer study, please. Okay? Unless we have any objection. All right, seeing no objection, please call the roll.
Okay. House Bill 466, Delegate Embry, Civil Actions, Motor Vehicle Accidents Involving Vulnerable Individuals, Comparative Negligence. The motion is to refer it to interim study. The Vice Chair. The Vice Chair votes aye. Delegate Valentine. Delegate Valentine votes no. Delegate Embry. Delegate Embry votes aye. Delegate Cardin. Delegate Cardin votes aye. Delegate Phillips. Delegate Phillips votes aye. Delegate Congolo. Delegate Congolo votes no. Delegate Stinnett. Delegate Stinnett votes aye. Delegate Simmons. Delegate Simmons votes aye. Delegate Boucher is absent. Delegate McComas. Delegate McComas votes no. Delegate Moreno. Delegate Moreno votes aye. Delegate Arcon. Delegate Arcon votes aye. Delegate Taylor. Delegate Taylor votes aye. Delegate Simpson. Delegate Simpson votes aye. Delegate Mangione. Delegate Mangione votes no. Delegate Moon. Delegate Moon votes aye. Delegate Conaway. Delegate Conaway votes aye. Delegate Woods. Delegate Woods votes aye. Delegate Williams. Delegate Williams votes aye. The tally is 14-4-0-0-1. House Bill 466 has been referred to interim study.
Okay. Thank you very much. Moving right along. We're going to go to House Bill 492. This is, wait, yep. Give me 1 second here, 1 second just to get myself together. Why did I take out 492? Okay, House Bill 492 has an amendment. Is there a motion on the amendment? Is there a second? May I have a second? Second. Thank you. Okay. What's the amendment? Okay, we're going to talk about the amendment, but I need a motion first. Okay, so the amendment merely strikes out on page 1, line 16, the word peace and substitute police.
Madam Chair.
Delegate Valentine has a question.
I do. I'm looking at the bill and I'm looking at the amendment, and I think it should be page 1, line 17, because there's no police in line 16.
Line 17.
Yes, that's correct. That's correct.
So,
17 must need to pop.
all right, so can we do this amendment in theory, or not in theory, but an oral amendment? So instead of line 16, it will strike in line 17, and we'll make that correction so that'll be correct for the floor. That is a very small amendment. So can I just get?
I move to the conceptual amendment.
Okay, thank you. All in favor of the conceptual amendment of line 17, please raise your hand. Okay, anyone opposed? All right, seeing none. Now, on the bill as amended. Thank you. Do we have any questions on the bill as amended? All right, seeing none, please call the roll.
House Bill 492, Chair, Judiciary, Maryland Judicial Conference, Courtroom Security, Minimum Adequate Security Standard. The Vice Chair. Vice Chair votes aye. Delegate Valentine. Delegate Valentine votes aye. Delegate Embry. Delegate Embry votes aye. Delegate Cardin. Delegate Cardin votes aye. Delegate Phillips. Delegate Phillips votes aye. Delegate Congolo. Delegate Congolo votes aye. Delegate Stinnett. Delegate Stinnett votes aye. Delegate Simmons. Delegate Simmons votes aye. Delegate Boucher is absent. Delegate McComas. Yes. Delegate McComas votes aye. Delegate Moreno. Delegate Moreno votes aye. Delegate Arcon. Delegate Arcon votes aye. Delegate Taylor. Delegate Taylor votes aye. Delegate Simpson. Delegate Simpson votes aye. Delegate Mangione. Delegate Mangione votes aye. Delegate Moon. Delegate Moon votes aye. Delegate Conaway. Delegate Conaway votes aye. Delegate Woods. Delegate Woods votes aye. Delegate Williams. Delegate Woods, you can, no. Okay. Delegate Williams votes aye. The tally is 18-0-0-0-1. The motion carries.
All righty, we're going to move now to House Bill 501. All righty, on 501, let's see for a second. Let's see if this was on the prayer list. No, it wasn't. It didn't. Okay, great. So I heard a motion on the on 501, and I heard a second. Are there any questions? All right. Seeing no questions, please call the roll.
House Bill 501, Delegate Bartlett, Criminal Law, Sexual Offense by a Position in a per person in a Position of Authority. The Vice Chair. Vice Chair votes aye. Delegate Valentine. Delegate Valentine votes aye. Delegate Embry. Delegate Embry votes aye. Delegate Cardin. Delegate Cardin is excused. Delegate Phillips. Delegate Phillips votes aye. Delegate Congolo. Delegate Congolo votes aye. Delegate Stinnett. Delegate Stinnett votes aye. Delegate Simmons. Delegate Simmons votes aye. Delegate Boucher is absent. Delegate McComas. 501. Delegate McComas votes aye. Delegate Moreno. Delegate Moreno votes aye. Delegate Arcon. Delegate Arcon votes aye. Delegate Taylor. Delegate Taylor votes aye. Delegate Simpson. Delegate Simpson votes aye. Delegate Mangione. Cannot add because it is favorable only. Delegate Mangione is a yes. Delegate Moon. Delegate Moon votes aye. Delegate Conaway. Delegate Conaway votes aye. Delegate Woods. Delegate Woods votes aye. Delegate Williams is excused. The tally is 16-0021. The motion carries. And the chair votes aye. The tally is 17-0021. The motion still carries.
38, Delegate Cardin, judge mandatory retirement age has an amendment.
Move the amendment.
Second.
Okay, on the amendment, Holly, do you want to talk about the amendment? Before I do, hold on, Delegate Erickson, do you have a question yet? Okay. So Holly, if you would speak up to the amendment, please.
Sure. The bill adds a provision that prohibits a judge of the Orphans Court from continuing in office after the judge's 73rd birthday, thereby mandating a mandatory retirement age of 73 for all Orphans Court judges, lining it up with the rest of the bill that raises the retirement age of judges from 70 to 73 in the state. Currently, Orphans Court judges are not subject to a mandatory retirement age.
Okay, so on the amendment, do you have a question on the amendment?
On the amendment, I'll
Okay.
say I do like the idea of giving a bottom for the Orphans Court judges. I think everybody sits in the judiciary should have that. However, I still have reservations about changing from 70 to 73. This is our only mechanism to get all of our jurisdictions over the years have had a judge that has been a very difficult character, but has not met the qualifications for removal under any other part of the code. And we have been waiting for the 70th birthday of some of these folks so that we could get somebody a little bit more reasonable in those positions. And so while I don't know of any of that occurring currently, it's not that it cannot happen. And so I would just caution against making a change like this when this is sometimes our only avenue for getting some fresh eyes on some of the cases in our jurisdictions. And this really applies to everybody, not just where I live. So I'll still be a no on the bill.
All right, thank you. Are there any other comments on the bill? On the amendment, I'm sorry. On the amendment. Delegate McComas, and your mic. Can you just, yep.
I think the problem is that, as Delegate Arkin effectively articulated, there are some judges that don't like some of the judge work that they have to do, and domestic violence is not violence, but just domestic cases, custody cases, and they don't have the temperament for it. They might have been an attorney that did transactional work, or they were they did business, corporations, that kind of stuff. Silk stocking work, in the sense that they didn't get their hands dirty with criminal or domestic. And I think we should just leave it at 70. And I think that put in the amendment, or maybe 70 and a half, and put in an amendment that the Orphans Court can't be there till they're 90. So I think that's what we should do.
No, she said they can't be there until they're 90. It was sarcasm, folks, it was sarcasm.
Okay.
So that's just my thought, because I had one of my worst cases in front of a judge that did a lot of transactional work, and my poor client had MS and couldn't talk and couldn't walk that well, and we had an on the other side.
I gotcha.
So I'm just saying, you just don't. People have to have their chance to go to the judiciary and be heard and a decision made, and just not have to deal with all that other underlying stuff that you can't send them to the Judicial Disability Commission. So I just think it's maybe better, because they have, circuit court judges and judges in general have so much power, and I think the common man doesn't understand how much power and how they can change people's lives. So that's my concern.
Okay, thank you. Delegate Simmons.
Thank you, Madam Chair. And just speaking to the competency of the judges, we heard some great testimony on the fact that there are this working group that has been put in place to make sure that they review judges in real time and what's taking place. in that work environment and with the recommendations that was brought before this committee, as well as when you look to the age. I have a cousin that's a appellate court judge in New York, and theirs is at 75. So there is a lot of positive feedback, and also when it came to the fiscal note of the money that's saved by having them remain in office during that period of time, and if there are any issues with them, that there's a screening process that's in place that would allow for them to address it as needed. So I ask that we move favorable on this bill. Thank you.
Any other comments on the amendment? The Vice Chair.
I know that there is a significant budgetary benefit to this. Can someone speak to that?
Yes, Delegate Carter.
Yeah, so the fiscal analysis shows that this is going to have a $21 million benefit to the state in savings, which certainly in this year and in the future years would be very much welcome given our financial status. The reason for that, if anybody's curious, is because there will be presumably less pensions being paid out because you don't get your pension until you retire. And so you will have fewer retirements based on the actuarial analysis done. Or there will be fewer years of retirement. So for that reason, it will benefit. I'll talk to the bill specifically, or the general on the bill after we do the amendment.
So technically, the amendment, okay, Delegate Valentine.
The amendment does not have any impact, by the way, on the finances of the bill.
Right.
Fiscal of the bill, according to the fiscal analysis, interestingly.
No, that's fine. But what I was saying was,
You would think it
the amendment is, if I understand it correctly, the amendment is merely adding the orphans court judges and their retirement. So that's what the amendment does. And that's where we are. We're on the amendment. Delegate Valentine.
I believe it might be to the bill, not the amendment, then.
Okay. All right, well, let's go with the amendment now. Since there's been a motion and there's been a second on the amendment to add, to include orphans court judges' retirement, mandatory retirement age of 73. All in favor, please raise your hand. Okay, any opposed? All right, seeing none. Now, on the bill as amended. Oh, thank you. What was that? All right, okay, thank you. So we have a motion and a second on the bill as amended. Delegate Valentine, do you want to make your point or ask your question now?
Thank you, Madam Chair. My point was to the cost savings that the good delegate just brought up. But you're not saving money, it's just where it's coming from. So instead of it being coming out of their budget, wouldn't it be coming out of the pension or vice versa? So it's just a shifting of where that money, you're not actually saving $21 million.
Well, you are,
How?
You're paying for people to work versus people not to work.
Right. Because at 70, currently,
If I'm not working, then I'm also paying for the person that I've replaced them with.
And you got to pay for it. Otherwise,
okay, so was that clear? That last comment, Delegate Phillips, could you say that again?
So if in fact you left at 70.
Could you use your mic?
If in fact you retired at 70, and so that means somebody else is coming in to fill your position, and I'm now paying your pension funds at the same time. So overall, I've got two salaries for those 2 years that I am compensating someone to be in that role, whether as a retiree or as an existing judge.
But it's out of two different funds, so it would not be saving the judiciary money. It's coming out of their pension, which is a different fund, a different bucket of money.
Different pool of money.
A different pool of money is my point.
Well, I mean,
Well,
yes and no.
well, it actually, okay, did you want to go over it? It looks like the general funds where the state pension contributions exist would decrease. So the general funds where the state pension liabilities would decrease. There is no effect on revenues. I'm just reading here. I don't want you all to think anyway. So it's not going to have an effect as in bringing in revenue. So that's where they're saying that it's mostly saving. We're using the word saving in the sense of what we don't have to pay out. It's not saving as in generating revenue. Yeah. Okay. Delegate Congola.
You, Madam Chair. So I get what you're saying. You're saying you're not paying, a salary and a pension, so that's where the savings is coming in. But can you help me understand how the pension system works? So is it based on the number of years of service, or is it strictly based on age?
I can add to that. So it's similar, but similar to the way our pension works, where you vest after a certain number of years, but then it increases up to, I believe, the same about 66% of your salary, and it completely vests at 16 years. Delegate Simpson would probably be a better person to answer this question, but knowing a little bit about how it works. So after 16 years, there's no increase in the amount that you're going to get from your pension.
Okay. So
if you start at 54 and you retire at 70, you will have the full pension. If you start at 56 and you
73
and the retirement's 70, then you do not get your full pension.
Got it.
Most
okay.
judges, as we are finding historically, people applying for judge can't afford necessarily to apply in their 40s, so they oftentimes apply in their 50s and 60s. Like we had a judge who applied and was selected as a judge and a circuit court judge, and then ran for the election. Judge Dealey, who was 65 and a few months. He didn't even qualify for health benefits because you need to be in your judgeship for at least 5 years. And so he just didn't even get the health benefits from, or the pension benefits, because you had to be in at least 5 years in order to originally vest.
Okay, so then now that you explain that, then we could potentially save money, because there will be some, I hate to sound mean, but there will be some who won't qualify because they got into the position too late. Because you're saying basically you would have to be your age or my age, somebody born in 1973, if they were to become a judge now, and you have this, you're vested 17 years and you stay until you're 73, then you'll get full pension. But for someone who may have gotten into this position at 55 or 60, they won't qualify. So this doesn't sound like a savings to me when you think about the numbers of years vested.
So the actuarial report, or the actuarial study done basically says, and to not be too morbid, but I'll be morbid, that if you retire at 73, you're closer to the time you're going to die. So you're not paying that pension versus the incremental amounts that you increase your vesting of your pension for the number of years that you work, which is less than the amount that you're being paid out annually on your pension. That's the study that they did, and that's why there's the huge savings.
So when will this system, this 73, kick in? When will this go into effect?
So this is a constitutional amendment, so it has to be passed by the voters, and then it would kick in, and it would be, is it immediately upon the certification of the election, or is it at the?
It's 30 days.
30 days?
So, or are you talking about the financial part, or are you talking about
when does it kick in that you're required to retire at 73?
As soon as it passes by the voters. And I think constitutional amendments, it takes 30 days to become effective. But essentially, if somebody is not, if somebody is in that window, they can continue to their 73rd. Just like if you reverse it for the orphans court, if you're over 73, unfortunately, you're going to have to step down and retire, and their, appointment will be made to fill that vacancy.
So you basically have 30 days to.
So the ballot and the qualification of the judge is simultaneous.
Got it. Okay, so so the judges, they can be appointed and elected, or this applies to all judges, whether they're appointed or elected?
Yes.
Yes.
Okay, all right. So I don't.
As amended.
As amended,
with-
sure.
yes.
Yeah, okay. So I don't know why this bill seems as if it is enabling folks who may be getting in too late. Like, they want to make sure that they're getting a pension and benefits.
Right.
So for someone who's 53 years old, 54 years old, if they get in now, then they'll get full pension. So it just seems to me that it's going to cost us more because, because these number of years, it's not really saving us any money. If anything, I think it's just giving people more time to get in and, be fully vested.
Well, it's the same as it is now. So we're not truly changing the pension system. So if someone gets in now at 53, they will be fully vested at 70. Okay? So we're not changing the structure. We're saying that you're fully vested at 73 as opposed to 70. So I'm not sure how it incentivizes someone to get in if they weren't going to get in at 70. That's the only thing I wasn't sure about. Because I think if they're going to get in, they're either going to have to retire at 70 or they're going to have to retire at 73. It's 3 years. You get 3 years.
But then you have someone who's, pursuing the seat and they're, coming of age and they better be in before they're 56. So it just seems as if there's a motive to protect someone of a certain age to get in so they can get full benefits by the time they're 73. Just doing the math, I don't see the financial benefit here. It just sounds like a middle-aged person that wants to make sure they're fully vested.
That the savings is a kind of a misnomer in the sense of it's not a revenue generation. It's literally not spending. That's how you're saving. You're saving, you're not spending. So it's not like we're creating a revenue, we're just not using the money. So that's how it becomes a savings. Delegate Simpson has been very, very quiet over there because I don't think she wants to join in. So Delegate Cardin?
I want to just comment on that. So if you remember the testimony from the hearing, that's one of the reasons why some of the advocates believe that it's a good idea, is that you have 65% of the bar is from the private sector, non-public officials, non-state's attorneys, non-public defenders, but 50+% of the people on the bench are from the public sector. So there's a question as to why we're not attracting people from the private world. And one of the answers is that they can't necessarily afford it, or they don't want to give up their practice. And so how do you encourage people who might not be 28 or 38 years old to apply to the bench? You make it that some better incentive when they're maybe in their 50s to apply as opposed to in their 40s. And so that could be, and so you get people with a tremendous amount of experience, whether it be in the public or the private sector, to be able to say that this is a worthwhile endeavor, even though they're going to take a salary cut, but they're going to actually access a pension or full pension if they still apply in their mid-50s. So that's one reason. Now, you can look at it the other way. You look at it differently. I just happen to think that's we want to have the best people on the bench so that, as Delegate Arcand said, we're not worrying about people that we don't think should be on the bench be there. So we want to ask the best people to apply. The judiciary should reflect the public that it serves, and here I'm going to just, life expectancy, workforce longevity have increased since the enactment of Article 4, Section 4 of the Maryland Constitution in 1851, which is when 70 was life expectancy in 1851 was around 40 years old. Life expectancy today is about 80 years old. The question is 73 the new 55, where people are very capable of continuing to be judges at a little bit older of an age. We're talking about 3 years. We're not talking about 10 or 15. And then there is, if you look at our surrounding states, Pennsylvania at 75, DC is 74. The Virginia is in the process, it has a bill right now to change it to 73. Perhaps they'll pass that as well at the same time we do. And then so I could go on with a couple other reasons, but I just think it's given the fiscal impact as well as the sort of the natural idea that the only place in our whole state where you have to retire at 70 pretty much is the bench. I just think that we ought to give our judges an ability to stay on.
Okay, and keep in mind that we did have Mr. Santini who came in, former MSBA president, and he said, and he clearly said, I'm not using any words he didn't say, but he didn't come in as a young man. He said he was coming in and as an older man, and he wanted, he would love to be able to be on the bench. He is still serving in so many other capacities to the legal profession. So it's for the young and old.
It definitely sounds like it, and that's why I'm saying that I don't see where it's a financial impact, because it just gives them more time. But I don't want to, belabor the point. I know we have to move on. I'm definitely not in support of it. I don't think that we're having an issue recruiting judges that are, in their 40s. I think someone in their 40s has good experience, me being one of them, if you've been in the profession long enough. I'm just curious to know how many judges, the percentage of judges actually stay until they're 70. Is that a high percentage? Okay. Yeah.
Okay.
Thank you.
This doesn't impact
Delegate Simpson.
There is a mandatory age of retirement for state employees if you have left service and you are no longer. So there is actually one, and it is based on actuarial, and it's like 70 and a half. So, but that's beside the point. There are a multitude of issues that I've heard about the judges, whatever you want to do with them. They want this. And it's exactly correct. It allows them to serve longer. There are ones that feel that they can serve longer. You can be a judge as early as age 30. They don't typically make it through at that young age because often they feel like they don't have enough experience. So I do know a lot of folks who are younger who have tried to go through the process to be appointed as a judge, and they are told, well, you're kind of young, keep applying, that kind of thing. So there is that. So I don't know that there is, I have also seen the process that there aren't a whole lot of people that are on those lists. So there is some argument to be said that, they're not getting as much recruiting. I have heard that they wanted to extend the age so that you have people who are able to do their private practices for as long as they can and then do judgeship. Because they felt that was an argument, if you recall, when they were talking about raising the salaries of people really being able to survive on those salaries, so to speak. They are vested at 5 years, so you could subtract that little 73, whether from the 70 or they can get their retirement as early as age 60. And then there hadn't been previously a disability, but there is, and it is, as the good delegate said, it's based on, so it's like our benefit that it is based on a sitting judge's salary. So if a judge gets a higher salary, if we approve that, then everyone who is a retired judge gets one. But that was involved. What is the other? There was another one that's like trying to extend the period of time and then be able to sit. The senior judge, it seems to be kind of, do you have any questions of me specifically?
Nope,
Okay.
this was super helpful. I appreciate your expertise on this particular issue. Keep in mind that ultimately this goes to the ballot.
Right.
And ultimately it's the voters who will make this decision. This is simply allowing it to be on the ballot. And not every ballot question always wins. Just want to say that is a thing. It doesn't always win. Delegate Simpson.
I will say we are also saying what's going to be on the ballot. So yes, we have talking about this is important because specifically what would end up being on the ballot is what we're talking about, what's in the bill. So if that makes sense.
All right, is there any other discussion? Delegate Valentine.
Thank you, Madam Chair. I just wanted to follow up with the ballot point, and ultimately, yes, the voters of this state will decide, just like they did in '94 when they voted this measure down. So,
Well, it wasn't quite this measure, wasn't it 70?
75. It would have been
Thank you.
70 to 75.
It was 75.
When it was voted down.
And that was in '94, before some of us were born. Okay, moving right along. I have to tell you all jokes every now and then to make sure you're awake. Okay, do we have any further questions or comments, thoughts or concerns? All right, let's call the roll, please.
House Bill 638, Delegate Cardin, judges mandatory retirement age, the Vice Chair. The Vice Chair votes aye, Delegate Valentine. Delegate Valentine votes no, Delegate Embry. Delegate Embry votes aye, Delegate Cardin. Delegate Cardin votes aye, Delegate Phillips. Delegate Phillips votes aye, Delegate Congolo. Delegate Congolo votes no, Delegate Stinnett. Delegate Stinnett votes aye, Delegate Simmons. Delegate Simmons votes aye, and an add. And Delegate Boucher is absent. Delegate McComas? Delegate McComas votes no. Delegate Moreno? Delegate Moreno votes aye. Delegate Arcon is excused. Delegate Taylor? Delegate Taylor votes aye. Delegate Simpson? Delegate Simpson votes sure. Delegate Mangione? Delegate Mangione votes aye. Delegate Moon? Delegate Moon votes aye. Delegate Conaway? Delegate Conaway votes aye, and an add. Delegate Woods? Delegate Woods votes aye, and an add. Delegate Williams? Delegate Williams votes aye. The tally is 13-3-0-1-1, or sorry, 14-3-0-1-1. The motion carries.
Thank you. And Delegate Woods, would you look at House Bill 216? I'm going to ask the body if we would approve Delegate Woods voting since she was out of the room when we.
You mean Williams?
Oh, Williams, I'm sorry. It was Williams.
I would love to vote.
Okay. Does anyone have any objection to Delegate Williams voting? Okay. Okay. Can we do that now? Okay. What is your vote, Delegate Williams?
Aye.
Aye. Okay. On 216. All right. We're going to move now to House Bill 713. This is a Cecil County delegation bill, sorry. I do not have an amendment. Thank you. And I heard a second. So there is a motion for favorable. There is a second. Presumably, there is a letter. Okay. All right. So do we have any questions? Or are we still on other bills that we've already passed? All right. Let's call the roll on House Bill 713.
House Bill 713, Cecil County delegation, Cecil County Orphans Court judges, compensation. The Vice Chair.
Yes.
The Vice Chair votes aye, Delegate Valentine. Delegate Valentine votes aye, Delegate Embry. Delegate Embry votes aye, Delegate Cardin. Delegate Cardin votes aye, Delegate Phillips. Delegate Phillips votes aye, Delegate Congolo. Delegate Congolo votes aye, Delegate Stinnett. Delegate Stinnett votes aye, Delegate Simmons. Delegate Simmons votes aye, Delegate Boucher is absent. Delegate McComas. Delegate McComas votes aye, Delegate Moreno. Delegate Moreno votes aye, Delegate Arcon is excused. Delegate Taylor. Delegate Taylor votes aye, Delegate Simpson. Delegate Simpson votes aye, Delegate Mangione. Delegate Mangione votes aye, Delegate Moon. Delegate Moon votes aye, Delegate Conaway. Delegate Conaway votes aye, Delegate Woods. Delegate Woods votes aye, Delegate Williams. Delegate Williams votes aye. The tally 17-0-0-1-1. The motion passes.
Thank you. Okay, we're going to move on now to House Bill 738. This is Delegate Phillips, transfer on death deed. Is there a motion? Okay, sorry. We're going to move the amendment. Thank you. So on the amendment, Holly, would you like to explain what the amendments do, or do you want to explain, Delegate Phillips? Okay, Holly. Thank you.
Of course, of course. Amendment number 1 is technical. Amendment number 2 strikes an exception excluding transfer on death deeds from the recording of an intake sheet. Amendments are really starting on page 13 or 14 of the bill. So if you start on 13, you'll see what I'm reading. Alters the definition of joint owner, that's on page 14. Adds provisions relating to transfer on death deeds that designate multiple beneficiaries. Alters provisions relating to the revocation of a transfer on death deed once it's been previously recorded. Strikes a provision relating to 2 or more designated beneficiaries and concurrent interests. It adds clarifying language, and then it alters the forms that may be used to create a transfer on death deed and the form that may be used to provide notice of the death of a transferor.
Are there any questions as you absorb that information?
And I will say this to go through the subcommittee, States and Trusts, and it was unanimous.
All righty. No questions? All right. So all in favor of the amendment, please raise your hand. All right. Looks unanimous. All right. On the bill as amended?
Move the bill amendment.
Thank you. All right. It's been moved and seconded that we move favorable on the bill as amended. Are there any questions? All right. Seeing none, please call the roll.
House Bill 738, Delegate Phillips, real property transfer on death deed, establishment, the Vice Chair. Vice Chair votes aye, Delegate Valentine. Delegate Valentine votes aye, Delegate Embry. Delegate Embry votes aye, Delegate Cardin. Delegate Cardin votes aye, Delegate Phillips. Delegate Phillips votes aye, Delegate Congolo. Delegate Congolo votes aye, Delegate Stinnett. Delegate Stinnett votes aye, Delegate Simmons. Delegate Simmons votes aye, and an add. And Embry also would like to add. And of course, Delegate Boucher is absent. Delegate McComas. Delegate McComas votes aye, and an add. Delegate Moreno.
Yes, and an add.
Delegate Moreno votes aye, and an add. Delegate Archon is excused. Delegate Taylor. Delegate Taylor votes aye, and an add if she's not already on it. Delegate Simpson. Delegate Simpson votes aye. Delegate Mangione. Delegate Mangione votes aye. Delegate Moon. Delegate Moon votes aye. Delegate Conaway. Delegate Conaway votes aye. Delegate Woods. Delegate Woods votes aye. Delegate Woods and Delegate Conaway both voted aye, and an add. Delegate Williams. Delegate Williams votes aye and is already on the bill. The tally is 17-0011. The motion carries.
All right, we're good on additions. Let's go to House Bill 980. There is an amendment. No, I'm skipping 921. I'm sorry, I forgot to tell you all that. Skipping 921. I'm going to House Bill 980. There is an amendment. Thank you. Is there a second? Second. All right, on the amendment, Lauren, would you explain this extensive amendment?
Sure. The amendment strikes the bill as introduced and codifies the Guardianship Assistance Program in the Department of Human Services, which currently exists in regulations, to promote the placement and maintenance of children in permanent guardianship homes by providing guardianship assistance to guardians of minor children. And it creates a state foster youth ombudsman in the department to provide legal expertise, neutrality, and advocacy for children in child welfare matters.
Are there any questions on the amendment? Give everybody time to absorb and read if you need to.
The amendments, there's no opposition, right?
Was there opposition before? No, I just want to make sure too. Oh, okay.
But, yeah,
Oh, yeah, there was some opposition, but, you know the old adage, you can't please all the people all the time.
Well, it struck so much of the bill, so.
Yeah, the bill is not the same as when it came in. It's got a lot less information in it, and now it really does work mostly to the guardian assistant program and making sure that there's an ombudsman in place, which is very, which is important. It's a companion to two other bills. Yep, one being the speaker's bill. Yep. All right, do we have any questions on the amendment? All right, seeing none. On the amendment, all in favor, please raise your hand. On the amendment. All right, it looks unanimous, thank you. On the bill as amended.
Second.
It has been moved and seconded and a favorable on the bill as amended. Are there any questions? All right, seeing none, please call the roll.
House Bill 980, Delegate Griffith, Family Law and State Government, Child Protection in the Office of Child Welfare Ombudsman, Kanaya's Law. The Vice Chair. Vice Chair votes aye, Delegate Valentine. Delegate Valentine votes aye, Delegate Embry. Delegate Embry votes aye, Delegate Cardin. Delegate Cardin votes aye, Delegate Phillips. Yes. One moment. Delegate Phillips votes yes in an add. Delegate Congolo. Delegate Congolo votes aye. Delegate Stinnett. Delegate Stinnett votes aye. Delegate Simmons. Delegate Simmons votes aye and an add. Delegate Boucher, absent. Delegate McComas. Delegate McComas votes aye and an add. Delegate Moreno. Delegate Moreno votes aye and an add. Delegate Eric Archon is excused. Delegate Taylor. Delegate Taylor votes aye and an add. Delegate Mangione. Oh, sorry, Delegate Simpson, I apologize. Delegate Simpson. Delegate Simpson votes yes and an add. And for the record, Delegate Mangione voted aye. Delegate Moon. Delegate Moon votes aye. Delegate Conaway. Delegate Conaway, is that an aye and an add? Delegate Conaway, yes and an add? Okay. Delegate Conaway votes yes and an add. Delegate Woods. Delegate Woods votes yes and an add. Delegate Williams. Delegate Williams votes yes. The tally is 17-0011. The motion carries.
All right, thank you. All right, we're going to move on to House Bill 1272. We have an amendment. The amendment was explained on the day that we held the bill. I don't remember if that was yesterday or not, but so there was some discussion around the section where we state that there has been a previous or current allegation of abuse or neglect alleged against the individual by the child's parent, or another relative of the child. The discussion was whether or not we should keep that out, or remove that as being redundant. I've talked with some of the folks who had the concern, and it is my request that we keep that because we are talking about allegations as opposed to a formal CPS process. The allegations may very well be made against the individual by the child's parent or another relative, but they may not have been processed through CPS. So with that said, I'd like to keep that in, and so now the amendment is as it was discussed before, and if there's any questions on the amendment, please let me know. In fact, we should probably move the amendment first.
So moved. Second.
Okay, thank you. So are there any questions on the amendment? I'm speaking about Amendment 853726. Do we have any questions? And also given what I just said. All right, seeing none. On the amendment, all in favor, please raise your hand. All right, it looks unanimous. On the bill as amended. Okay. On the bill as amended, there's a motion favorable and a second. Are there any questions? All right, seeing none, please call the roll.
House Bill 1272, Delegate Osivero, Family Law, Kinship Care, the Vice Chair. Vice Chair votes aye, Delegate Valentine. Delegate Valentine votes aye, Delegate Embry. Delegate Embry votes aye, Delegate Cardin. Delegate Cardin votes aye, Delegate Phillips. Delegate Phillips votes aye, Delegate Congolo. Delegate Congolo votes aye, Delegate Stinnett. Delegate Stinnett votes aye, Delegate Simmons. Delegate Simmons votes aye and an add. Delegate McComas.
Yes.
Delegate McComas votes aye, and as a reminder, Boucher is absent. Delegate Moreno. Delegate Aricon is excused. Delegate Taylor. Delegate Taylor votes aye and an add. Delegate Simpson. Delegate Simpson votes aye. Delegate Mangione. Delegate Mangione votes aye. Delegate Moon. Delegate Moon votes aye. Delegate Conaway. Delegate Conaway votes aye and an add. Delegate Woods. Delegate Woods votes aye. Delegate Williams. Delegate Williams votes aye. The tally is 17-0011. The motion carries.
Thank you. All right, so we're going to move now to House Bill 1326. This is Delegate Wilson, Child Abuse and Neglect, Disclosure of Reports and Records. There is an amendment. Excuse me. Are there any questions on the favorable motion on the amendment? Well, let's talk about what the amendment does, please, Lauren.
The purpose of the disclosure of the record must be to determine the suitability of an individual for employment or voluntary service.
On the bill as amended, is there a motion?
Second.
Thank you. Are there any questions on the bill as amended? Delegate Valentine.
I just had a question.
Sure.
I know we talk about the fiscal notes. I know, but some of the fiscal notes have kind of been all over the place this year.
Right.
And I'm just trying to confirm that what's in the narrative portion of the fiscal note is not where it's talking about additional staff of multiple people, hundreds of thousands of dollars. Has that been addressed? Is that accurate or not?
Well, if you also look on the fiscal note on page, what is it, 2? 3, page 3, where it states, oh, I was going to go down here. Okay, is it up here? Okay, so on page 3, on the paragraph where it says, the Department of Legislative Services, while acknowledging that the bill expands eligible recipients and therefore, et cetera, is unable to independently verify the need for additional staff at the magnitude indicated by DHS without experience under the bill. And then it goes down, and then it goes down and it states, however, regardless of any changes in procedure, the need for additional staff is primarily dependent on whether the bill results in a significant number of additional requests which cannot be reliably estimated in advance. And then they give us an illustrative purpose of saying that one additional program specialist would be about $67,000 in fiscal 27 and $83,000 on an annual basis. So this has been put forth to appropriations, and we got our approval based on what DLS is speculating.
On the one position or on the overall, what the?
On the one position. Yeah.
Okay,
Yeah.
thank you.
Do we have any other questions? All righty, seeing none. On the bill as amended, please call the roll.
House Bill 1326, Delegate Wilson, Child Abuse and Neglect, Disclosure of Reports and Records. The Vice Chair. Vice Chair votes aye. Delegate Valentine. Delegate Valentine votes aye. Delegate Embry. Delegate Embry votes aye. Delegate Cardin. Delegate Cardin votes aye. And an add. Allow me but one moment. Delegate Phillips. Delegate Phillips votes aye. And an add. Delegate Congolo. Delegate Congolo votes aye. Delegate Stinnett. Delegate Stinnett votes aye. Delegate Simmons. Delegate Simmons votes aye. Delegate Boucher, absent. Delegate McComas. Delegate McComas votes yes and an add. Delegate Moreno. Delegate Moreno votes yes and an add. Delegate Archon is excused. Delegate Taylor. Delegate Taylor votes yes and an add. Delegate Simpson. Delegate Simpson votes yes and an add. Delegate Mangione. Delegate Mangione votes aye. Delegate Moon. Delegate Moon votes aye. Delegate Delegate Conaway. Delegate Conaway votes aye and an add. Delegate Woods. Delegate Woods votes aye and an add. Delegate Williams. Delegate Williams votes aye and an add. The tally is 17-0011. The motion carries.
Sure. Are there any other additions to the sponsorship for that bill? You got everybody? You got Mangione? Okay. And also FYI, that did pass out of the Senate with no opposition, and it was 40-0. All right, we're going to move on to House Bill 1383. Delegate Guyton, Child in Need of Assistance, Permanency Plan Requirements. Is there a motion? Are there any questions regarding the bill? There are no amendments, as far as I can tell. Nope, there are no amendments. No questions? All right, seeing none.
Madam Chair.
Yes, Delegate Valentine.
I feel like this might be a reoccurring theme, but I'm seeing in this fiscal note the same kind of what we went through with the last one, where they're anticipating all this staff. Is this something that's been in a lot of bills this year? Yeah. I believe down in the very first paragraph where they're asking or thinking there's going to be 56 additional staff needed, and it kind of goes on and on. So kind of like what we talked about on the last bill.
Yes, in fact, yes. And in fact, the DLS says that, the note under the state effect states that the judiciary can implement the bill within their existing budget, and DHS can likely implement the bill within their existing budget. So they are assuming no direct effect on, well, no, on revenue. That's a whole nother point. But my point is that they're not seeing they're not seeing what DHS is seeing.
Thank you.
Put it that way. All right, are there any other questions? All right. Seeing none, please call the roll on House Bill 1383.
House Bill 1383, Delegate Guyton, Children in Need of Assistance Permanency Plan Requirements. The Vice Chair. Vice Chair votes aye. Delegate Valentine. Delegate Valentine votes aye. Delegate Embry. Delegate Embry votes aye. Delegate Cardin. Delegate Cardin votes aye. Delegate Phillips. Delegate Phillips votes aye. Delegate Congolo. Delegate Congolo votes aye. Delegate Stinnett. Delegate Stinnett votes aye. Delegate Simmons. Delegate Simmons votes aye. Delegate Boucher is absent. Delegate McComas. Delegate McComas votes aye. Delegate Moreno. Delegate Moreno votes aye. Delegate Archon is excused. Delegate Taylor. Delegate Taylor votes aye. Delegate Simpson. Delegate Simpson votes aye. Delegate Mangione. Delegate Mangione votes aye. Delegate Moon. Delegate Moon votes aye. Delegate Conaway. Delegate Conaway votes aye. Delegate Woods. Delegate Woods votes aye. Delegate Williams. Delegate Williams votes aye. The tally is 17-0011. The motion carries.
All right, great. And our very last bill is, well, yeah, until tomorrow. House Bill 1457, Washington County Delegation Bill. And is there a motion? Is there a second? All righty. So this is the Juvenile Truancy Reduction Pilot Program. Are there any questions on the bill? I have one question. All right, seeing none, let's take the roll.
House Bill 1457, Washington County Delegation, Washington County Juvenile Truancy Reduction Pilot Program. The Vice Chair. Vice Chair votes aye. Delegate Valentine. Delegate Valentine votes aye. Delegate Embry. Delegate Embry votes aye. Delegate Cardin. Delegate Cardin votes aye. Delegate Phillips. Delegate Phillips votes aye. Delegate Congolo. Delegate Congolo votes aye. Delegate Stinnett. Delegate Stinnett votes aye. Delegate Simmons. Delegate Simmons votes aye. Delegate Boucher. Absent. Delegate McComas. Delegate McComas votes aye. Delegate Moreno. Delegate Moreno votes aye. Delegate Archon is excused. Delegate Taylor. Delegate Taylor votes aye. Delegate Simpson. Delegate Simpson votes aye. Delegate Mangione. Delegate Mangione votes aye. Delegate Moon. Delegate Moon votes aye. Delegate Conaway. Delegate Conaway votes aye. Delegate Woods. Delegate Woods votes aye. Delegate Williams. Delegate Williams votes aye. The tally is 17-0011. The motion carries.
Delegate Cardin.
I do an introduction real quick.
Oh, sure.
I'd like to everybody to meet my high school intern doing his senior project down here for the month. His name is Nathaniel. He's waving to everybody.
Great. Hi, Nathaniel.
He's the one who put together the list for the interim clauses.
Oh, my
So
gosh.
And he also brought soft drinks for some of the members of leadership. So.
Nathaniel, can I just say, I looked at that product, your work product. It is very good. You're in high school? Yeah. What year? Well, great. You have a very bright future ahead of you. Yeah, are you interested in coming back to the General Assembly to work? I'm sorry, what was that?
Only God knows.
Only God knows. I know. Put it on the prayer list. Delegate Cardin.
See from his accent, and he was a COVID mover. He moved down here. They came down here for vacation in COVID and then never went home.
Well, welcome, and it's great to see you. Welcome to Judiciary. You're welcome here anytime. And members, do we have anything else for the good of the order? All right. Seeing none. We have session at 5:30. Session is at 5:30. All righty. Thank you, everyone. Bye-bye. We are adjourned.